Ontario's provincial government's lost a high-profile court challenge. A judge has ruled it's unconstitutional for Premier Doug Ford to slash the size of Toronto City Council right before municipal elections. The City of Toronto and other groups had fought against Bill 5. It attempted to cut the number of councillors from 47 to 25, redrawing the city's electoral districts. Now, a short time ago, Toronto's mayor reacted to the court victory.
Can't change the rules in the middle of a game. That's not fair to anyone, and this is not a game. It is an election campaign, one of the most fundamental foundations of our democratic system. The court has agreed with that, and I think this result justifies the decision of the City Council on a motion strongly supported by me as mayor to seek the independent judgment of the court.
And for more on the Toronto City Council ruling, we want to bring in Leo Longo. He is a senior partner at the law firm Aird & Burles. He's a certified municipal law specialist, and he joins us now live. So, Mr. Longo, let's start with your initial thoughts on this ruling. What did you make of it?
Well, I find that it is a stunning rebuke of the province and the timing of this legislation. What I find most fascinating is had the province just waited until after the election and introduced this bill, you wouldn't have had the challenge that you have seen taken in the court decision today.
Because specifically the judge pointed out the timing, right? That there's an election in about 6 weeks.
It's all about timing and the voters' rights to freedom of expression and effective representation, and the candidates' rights for freedom of expression were violated by the introduction of this legislation in the middle of the election. That's the fundamental and only grounds on which the judge has ruled.
Is it fair to say then that the judge was considering the voter in this?
Very much so. The right to vote means the right to effective representation. And the judge found that voters having one councillor representing 110,000 constituents just didn't give voters an effective voice to their councillor and to their city government. And so a good portion of this decision, and I think the most important part of this decision, focuses on the voters' rights to effective representation. Right. Recall that the city had done a 4-year exercise to determine what the proper size of voter representation should be for wards, and determined about 61,000 was about appropriate. Going to 111,000, the judge said there was just no evidence to suggest that voters would be, their rights would be enshrined and not be hurt by such legislation.
And that's because there's an election set for October 22nd. But what if there wasn't an election?
The judge even doesn't invite the province, but says, if in some future time after the election you wish to bring this kind of legislation forward, do so, and then it will be judged in the constitutional context of the time. But because it was brought during the election, it offended the constitutional rights of the candidates and the constitutional rights of the voters. So the judge has pretty much said, sit back, wait until this election is over, and try again. And then all the grounds on which I've granted this appeal now won't exist when anyone challenges the next bit of legislation.
Okay, well, we'll see if that's what the Premier decides to do when he addresses the media in a couple of hours. Mr. Longo, thank you for your thoughts.
My pleasure.
That is Leo Longo, a senior partner at the law firm Aird & Burles, joining us through FaceTime, live from Collingwood, Ontario. Let's turn now to CBC's Megan Fitzpatrick. She joins us live at City Hall. Can you run through the key details for us, Megan, in this developing story?
Yes, I can run through the decision, the arguments put forward by the judge, not the arguments, sorry, the reasons for his decision. He said that the province's law crossed the line and that it, quote, substantially interfered with rights that are protected under the Charter of Rights and Freedoms. Those were some of the arguments that were put forward by both the City of Toronto's lawyers and lawyers for a number of Toronto residents who also challenged this piece of legislation. And the justice wrote in his decision that really it hinged on the constitutionally protected right to freedom of expression. He took into account how that right was violated, in his view, for both candidates who were running in the election and for voters. And he said it really is all about the timing of this law. Had it been passed 6 months earlier, it would be a different story. But given that the province stepped in to change the size of City Council in the midst of the election campaign, that's why the legislation violated people's charter rights. And so he was saying, in terms of the candidates, they had made their decisions to run in a 47-ward model. They had raised money. They had printed campaign material. They were communicating with voters based on a 47-ward model, not 25. So when the province stepped in and made the changes, that interfered with their freedom of expression. And then from the voters' perspective, he said as well, he agreed with the arguments that people's rights to freedom of expression were impacted as well by Bill 5 and their right to cast a ballot in a fair election. He said Bill 5, the province's bill, essentially undermined a free and fair election that was already underway in the City of Toronto. So he said, had the bill been introduced at a different time, maybe it would have been found to be constitutionally sound, but as written and the timing of it meant that it violated Section 2 of the Charter of Rights and Freedoms, and so the justice struck it down. He said in his ruling, if the province essentially wants to try again with a similar piece of legislation, they can, but because of the timing of when the province stepped in, that's why he found it unconstitutional. So he said the election here in Toronto will proceed as scheduled on October 22nd, going back to the 47-ward model, how the boundaries had been drawn for that election, not the 25 model that the 25-ward model that the province was trying to impose.
So what kind of reaction are you hearing on this there?
Oh, plenty of reaction, as you can imagine, Rashmi. This was a very closely watched case here in Toronto and really around the province, too, because this is precedent setting. The justice wrote in his decision as well that this was an unprecedented case. And immediately this morning when the decision came out at 8 a.m., there were people here at City Hall reacting, including some candidates who were running in the election, and they were very happy. They were saying they're very relieved. They were grateful to the justice for siding with them and with the City of Toronto in this legal challenge. We heard a few minutes ago from Toronto Mayor John Tory. He said today's decision really justifies the City of Toronto's decision to challenge the province and take it to court, saying that City Hall was standing up for Toronto voters, that what the province tried to do wasn't right, it wasn't fair, that the province was trying to ram this down Toronto's throat with no consultation. So that's a bit of what we heard from John Tory. We've also been hearing from several city councillors here, including Mike Layton, who was in favor of the 47-ward model. Here's a bit of what he said in reaction a little while ago.
I think there's a clear message now coming from the judiciary to the province saying you need to follow the law. You must follow the rules that are in place. Just arbitrarily halving the size of council in the middle of an election will not stand. This is a positive decision for the city and for other municipalities in Ontario and across the country, saying, you know what, provincial governments, in this case Ford's government, you're going to have to follow the law if you're going to start making changes.
So a positive decision in his view, but not all city councillors are on the same page. There are some city councillors here in Toronto, at Toronto City Hall, who were okay with Doug Ford trying to cut down the size of city council here, including Jim Karagianis, who under the 25-seat model would have been up against a fellow city councillor. And he said this morning he was looking forward to that competitive race, and he's not as happy with today's decision that it'll go back to 47 seats on city council. Here's some of what he said.
Even before this, the 47 to 25, I have put a motion in council that we do go to 25. The unfortunate part is that a power above us, the provincial legislature, decided to do that. It was their mandate. Of course, they lost in court, and we move forward. And certainly something that we can look after for the next election. We need to make sure that we streamline and we make sure they have equal representation.
And of course, now the reaction we're really waiting for is from Premier Doug Ford and the province. What's next? Will they appeal this decision, or what are they going to do in reaction to it? And we will be finding that out, Rashmi, right around noon, when Doug Ford is planning on holding a news conference with reporters at Queen's Park.
Thanks, Megan.